that branches of an arbitral institution may be established in the territorial sphere of other arbitral institutions. Of course, the approval from the authoritative government is necessary, but the barrier to cross the territorial border of different arbitral institutions must move away for sure this time. And so the market of arbitration institutions become a unified one instead of separated segments. Furthermore, very recently, institutions like Sundra Arbitration Court, Thailand Arbitration Court, Langfang Arbitration Commission, and others have come to a new stage of reformation by which all the staff members' salaries and arbitrators' fees are to be decided by the institution themselves as per the market. They no longer need to follow the strict standards applicable to all the staff members of other state-owned entities like universities, hospitals, schools, academic institutions, and the public servants. What is more important is that more and more institutions of arbitration are moving in the same direction. Sooner or later, it seems that it won't be too long that these arbitration institutions in China will become truly not-for-profit legal persons offering arbitration services to the entities in the market instead of subsidiaries of local governmental bodies. At that time, in the near future, the geography and the overall picture of the Chinese arbitration institutions will be totally different, more and more suitable for the smooth and steady development of the economy. This is what I wish to share with you all on the marketization of Chinese arbitral institutions in the recent times and in the foreseeable future. So thank you very much for your great patience. So that's all that I'd like to say, Sajjad.
Thank you very much, Dr. Jian, for your insightful comments. I think I would agree with you that it is important for the Chinese arbitral institutions to marketize because of the growth of BRI. And I think now it's not just about Chinese arbitral institutions being domestic arbitral institutions, but truly global entities. So thank you very much for your comments. Now I'd like to invite our next panelist, Mr. Professor Sundra Rajoo, who will be talking about the disclosure of evidence and exclusion of illegal evidence in online arbitration. Mr. Sundra Rajoo is the founding president of the Asian Institute of Alternate Dispute Resolution. He's a certified international AIADR practitioner, chartered arbitrator, CIICA, advocate and solicitor, architect and town planner, director, Asian International Arbitration Center from 2010 to 2018, chairman, Asian Domain Name Dispute Resolution Center, deputy chairman, FIFA Adjudicatory Chamber back in 2018, president, Chartered Institute of Arbitrators in 2016, president, Asian Pacific Regional Arbitration Group in 2011, founding president, Society of Construction Law, Malaysia, founding president, Malaysian Society of Adjudicators, founding president, Sports Law Association. I could go on and on, but I'll just conclude by saying since 1990, he has served as chairman, co-arbitrator of 3-man panels and sole arbitrator in over 300 international and domestic arbitrations, including ad hoc and institutional arbitrations administered by ICC, CIAC, HKIAC, KIAC, CTEC, PCA, and KLRCA. Mr. Professor Sundra Rajoo, the floor is yours.
Hear me? My picture is gone. Can you hear me? Can you hear me?
Yes, we can hear.
Yes, I can hear you.
Okay. I have a problem, but my picture is not coming on. Can you see my power slides? With just 1 minute.
Sure.
Share screen. Can you see the power slides?
Yes.
Yes, I can.
You can see my power slides. I'm so sorry.
Yes.
Something wrong with the thing. A very good morning, afternoon, or evening to all the panelists. Thank you, Mr. Rana. And I thank the Beijing, sorry, I thank the Beijing Zhidong Technology Company Internet Arbitration Service Provider for organizing this virtual conference. It is a great honor for me to be here and to share this floor with some important people in dispute resolution and to share my views on the disclosure of evidence and the exclusion of evidence and the exclusion of illegal evidence on online arbitration. Now, as we know, the COVID-19 has been declared a global pandemic with widespread effects spanning throughout the jurisdiction. This pandemic has prompted international arbitration community to come up with means and methods to cope with the situation. Now, it has pivoted to a gradual shift to conducting proceedings physically to virtually to ensure the efficiency of arbitration. Arbitration hearings, which were previously scheduled in person, are now switched to virtual hearings. So in Beijing, service providers like the Beijing Zhidong Technology Company Limited plays a big role in maintaining the efficacy of arbitration. They help in ensuring the arbitration proceedings go on as scheduled by conducting virtual hearings. Despite lockdowns and restrictions on movement in one country to another, an impressive percentage of arbitration hearings took place last year. Based on the 2021 International Arbitration Survey conducted by the Queen Mary University, London, White and Case, it was found that 79% of the respondents would choose to proceed with the scheduled time as a virtual hearing. Only 16% would postpone the hearing until it could be done face-to-face, and only 4% chose to proceed with documents-only award. Though online arbitration is not a new concept, previously it was not a preferred means to conduct arbitration. Now online arbitration has been accepted by large. Now, in arbitration, large number of disputes, 60 to 70%, are determined by arbitral tribunals with no more than a passing reference to the law, but based largely on the question of fact, what was said, what was not said, what was promised, what was not promised, what was done, and what was not done. Moreover, international arbitral tribunals attach more weight to the contents of documents than oral testimony. This is because lawyers may prepare or coach their witnesses before the hearing, and it is possible that the memory of witnesses get tainted after years passing by. Thus, it's very important to establish the accurate facts with the help of documents. As we know, arbitration is popular because of its flexibility. There's no particular set of laws that governs arbitration. Parties can select any substantive law and more specifically, any procedural rules for arbitration. For example, parties can select the Indian Arbitration Act along with the CIICA arbitration rules based on China, or they can also, these rules do not regulate evidence disclosure in arbitration. Parties are free to opt for any procedure. Generally, where parties do not agree to a procedure, the tribunal exercises a wide discretion in this regard. Normally, the local law of evidence does not apply to arbitral proceedings. Now I will come to the IBA guidelines. Now this actually, because the local law of evidence does not apply to arbitration proceedings normally, this brings problems particularly to arbitrators. In international arbitration, parties can be both from common law or civil law jurisdiction. Common law allows a broad disclosure of evidence. However, in civil law, the court seldom orders for disclosure. Thus, the arbitrator have to opt for a middle path. It can be either broader or narrower. And this is where the IBA guidelines on evidence play a major role. It has been termed as a neutral and more preferable procedural law. It can be adopted as non-binding, guiding, or binding to be included in procedural orders. Many arbitral institutions have come up with various protocols and guidance notes on virtual arbitration hearings, which the parties may elect to apply, and they have been issued to assist the parties and to act as a supplement to the IBA guidelines. These include the ICC guidance notes on the possible measures aimed at mitigating the effects of COVID-19 pandemic. It provides a checklist for virtual hearing protocol that will ensure each party is treated equally and given full opportunity to present its case. The Chartered Institute of Arbitrators guidance notes on remote dispute resolution proceedings provides guidance on technology and logistical, legal, and procedural matters relating to virtual hearing. We also have the SOL protocol. In fact, the SOL protocol was the first protocol that came out on video conferencing in international arbitration, which provides best practice for virtual hearing. And then we have the HKIAC guidelines for virtual hearings, which provides practical guidelines on such matters as confidentiality, preparation of electronic bundles, transcription and interpretation services. And I've suggested an article that you can actually look in great detail by Yvonne Mark. The Vienna Protocol, a practical checklist for remote hearings, and the COVID-19 information and guidance from the Stockholm Arbitration Chamber, Stockholm Chamber of Commerce. Now, in January 1921, the IBA rules on taking evidence in international arbitration was amended to bring certain amendments into play. These revised IBA rules is considered as a good fit for online arbitration. And these changes include: one, adding a reference in Article 2 to issues of cybersecurity and data protection in the list of issues that the initial consultation on evidential issues may address. Two, adding the term remote hearing in the definition section, amending Article 8 to provide expressly for remote hearings and for the tribunal to establish a protocol for conducting such remote hearings. And three, adding a provision on Article 9 that the arbitral tribunal may exclude evidence obtained illegally. So I have been using this for all my international arbitrations now when I'm chair, and I think this has been quite important for us. In the procedure for the production of documents pursuant to the IBA guide rules, the tribunal at the earliest will conduct consultations with the parties, and during the consultations, and normally it will be during the case management, case conference meeting, that the tribunal will take decisions on certain aspects like requirements, procedures, format applicable for the production of drawing documents, the level of confidentiality protection to be afforded to evidence in arbitration, the treatment of any issues of cybersecurity and data protection. So after this consultation, parties have to submit a document on which they rely upon and request to produce documents to both the tribunal and the other party. The tribunal then will fix the time for the production of such documents. Here, the tribunal will supplement the procedure with duly relying on the International Arbitration Redfern Schedule. Now, diagrammatically, the Redfern Schedule is represented by a document request, the relevance and materiality of the request, the objection to the request, if any, and then finally the arbitral tribunal. Now, in the document request, the party had to specify the documents they require. The parties cannot arbitrarily make a broad document request like all the minutes of the meeting conducted in a particular year, but it could be minutes of meeting conducted in a particular month. And if it's an e-document, the party has to specify the search term. Now, where relevancy and materiality is concerned, there are two different terms. A document could be relevant to the dispute, but it may not be material to the outcome of the dispute. For example, the document that establishes the fact that damage has been done can be considered as relevant. But if the document submitted previously also established the same fact, then the request for new documents could be denied. Then you have the third part is objection. There are several objections that could be raised by the opposite party to whom a request for document has been made. Such objections could be like privilege, privacy important in a situation where the opposite party is a competitor, inability to access, or not in the party's possession. In a current situation, parties could tactically deny the request by raising objection. They were not able to access the documents requested due to lockdowns arising from the COVID pandemic. However, the tribunal will consider reasonable objections in reaching a decision on whether it is viable to accept such requests for document production or not. In the case of non-compliance of the tribunal's decision, the tribunal cannot pass cohesive order but draw an adverse inference as a sanction. Now I'm moving on to court assistance. Most arbitral legislation provides for court assistance for the disclosure of evidence. For example, Article 46 of the Arbitration Law of the People's Republic of China provides that if any party contemplates that evidence may be destroyed or lost or difficult to obtain at a later time, a party may apply for the preservation of such evidence. If the party applies for the preservation of evidence, the Arbitral Commission shall submit its application to the People's Court in the place where the evidence is located. The point that needs to be noted here is that the tribunal has the last say in the disclosure of evidence. The parties individually cannot reach the court for its assistance directly. Now, the UNCITRAL rules on transparency has emphasized the need for transparency in international dispute settlements systems. Where it is necessary for transparency, the tribunal must permit the disclosure of confidential evidence to ensure judicial efficacy in commercial arbitration. The disclosure of confidential information is permissible in situations such as where the documents are vital to dispose the case fairly, as in Ahmad versus Michael, or where the evidence cannot be obtained in any other way, such as in Dolling versus Barker case, and to avoid inconsistent findings, especially in cases where both parties have appointed the same arbitrator. A sole arbitrator. If the information is made available to the public, then the confidentiality duty does not apply, as seen in the case of the Persia International Bank. It is uncertain as to what amounts to the public domain and whether it covers leaks of information such as WikiLeaks scandal. It is also open to interpretation by the arbitral tribunal. The popular opinion following WikiLeaks and information is only considered as public domain when it's accessible to the World Wide Web. However, it is open to interpretation. It is possible that the mere connivance of information to a third party could fall under the public domain. As previously prior to the amendment of Article 9(1)(a) of the IBA rules of taking evidence, there was no express provision provided discretion to exclude, and the tribunals would have to determine this on a case-to-case basis and whether the illegal evidence was material to the outcome of the case. In the absence of express provisions within the lex arbitrii and the new IBA rules by Article 9(3) of the 2020 IBA rules, now there is discretion provided to the arbitral tribunal to consider or exclude evidence that has been obtained illegally by their own motion or by the request of the parties. Previously, for international arbitration, there was no unanimity on what standard should be applied to determine whether an evidence had been illegally obtained or such evidence would be directly inadmissible. Thus, in each case, it was the arbitrator who would exercise the discretion to exclude or include such evidence. The commentary under Article 9(3) of the 2020 IBA rules illustrate an example of a conversation being recorded without permission in a country where it would be illegal, would rightly be deemed illegal under Article 9(3) by the arbitral tribunal. The commentary further explained that while the 2020 IBA rules ideally was drafted to expressly specify what amounted to illegal evidence, there is no clear guideline. Some of the common considerations in deciding what amounted to illegal evidence are proportionality on whether the evidence was material to the outcome or has been already leaked to the public domain, or whether the party who is seeking to rely on the evidence is acting in good faith, and how severe the illegality is in question. In Corfu Channel, United Kingdom of Great Britain and Northern Ireland versus Albania, the International Court of Justice, ICJ, had to consider whether, in the light of evidence before the International Court and Tribunal, there was a rule to exclude illegally obtained evidence. Corfu Channel was the first and only concluded case to date in which the ICJ has pronounced on illegally obtained evidence. The court, however, did not address the issue on why the evidence was admissible, despite previously showing a strong stand against illegally obtained evidence. However, many academicians have inferred on the basis of the decision in Corfu Channel that it was the gravity of the intrusion in obtaining illegal evidence was not as grave as the wrongdoing that sought to be proven. The decision may potentially serve as a guideline on the proportionality test in determining the admissibility of illegal evidence. It should be noted that many institutional rules, even the Article 9(7) of the IBA rules, mandates the parties to act in good faith during the arbitration. The act of obtaining evidence illegally is in contrast to the act to act in good faith. Where a party acts in bad faith, that would be a factor for the courts to consider in deciding whether to exclude evidence. In Middlenex versus USA, the tribunal rejected to admit illegally obtained evidence because the party's conduct during the proceedings was in contravention of the principle of justice and fairness, which was essentially expected of all parties in international arbitration. An issue to be considered is that if the arbitral tribunal admits such evidence, it may provoke the other party to opt for the same means by obtaining evidence which has been objected to by parties in justifiable ground. It's actually an issue of incentivizing illegality. So moreover, it will be possible that an award that is based upon an illegality obtained may be in violation of public policy of some states. In contrast to what has been said, there is a duty on the arbitral tribunal to find the fact. So if illegally obtained evidence could make an impact to the outcome of the case, then the arbitral tribunal may allow the admissibility of such evidence. Not allowing may bring another challenge to the arbitral award on the grounds the right to be heard. So in conclusion, there is an international consensus in permitting the admission of illegally obtained evidence. Following the revision of the IBA rules, where illegal evidence can be excluded at the party's request, it is clear that party autonomy is now the fundamental principle. Illegally obtained evidence is admissible where it is relevant and material to the case, so long as the parties act in good faith. So I think that's what I have to say, but I can't seem to close. Let me stop sharing. Stop share. Sorry, can you see me now, Rana?
Yes, I
I've
can.
finished. Yep, sorry. Thank you so much. Apologize, it's a bit long. I've taken a bit longer than necessary. Thanks a lot.
Not at all, not at all. I'm glad you were able to cover ground, and because of course this is an important topic. And it's interesting to learn that at times the manner in which the evidence was obtained does not really matter as long as the substance of the evidence itself is relevant and material to the proceedings. And as you mentioned, that the IBA rules have also allowed this kind of evidence. And the assumption is that, of course, for all Belt and Road Initiative disputes, these are applicable wherever parties have adopted the IBA rules as well. So this is an interesting development. Thank you once again, Sundra, for your insightful comments. Now, moving on to the next panelist, Atty. Mario Valderrama, who will be talking about the validity of arbitration agreement, specifically under what circumstances the arbitration agreement would be considered invalid, and the solution for the parties that choose different arbitration institutions. Mr. Mario Valderrama is General Counsel in the Philippines Construction Industry Arbitration Commission. He's a law professor handling ADR and arbitration. He's the founder and currently President Emeritus of the Philippine Institute of Arbitrators. He's on the approved faculty list of the Chartered Institute of Arbitrators, East Asia branch. He's a fellow of the Chartered Institute of Arbitrators and the Hong Kong Institute of Arbitrators. He's an accredited arbitrator in PDRCI, CIICA, WSM, and arbitration. His experience ranges from serving as a legal expert witness in international arbitration, as party representative in arbitrations, domestic and international, counsel in charge of the file in PDRCI arbitrations, chair of arbitral tribunals, domestic and international, and ad hoc court-confirmed PDRCI, CIAC, and International Chamber of Commerce arbitrations, sole arbitrator in ad hoc domestic arbitration, sole arbitrator in an ICC arbitration, and serving as a panelist in several arbitral tribunals, both domestic and international. Mr. Valderrama, the floor is yours.
Right, thank you, Rana, for that wonderful introduction. And may I also thank the organizer for inviting me. So, so our objective is to provide an overview of the challenges against arbitration agreements. This is basic anyway. So we are already aware that the test is generally contractual. There are three: null and void, inoperative, or incapable of being performed. So when we talk about an arbitration agreement being null and void, well, we have unconscionability, lack of consent, fraud, mistake, lack of capacity, and illegality. Now, in many cases, the contracts signed by the parties are so-called contracts of adhesion or take it or leave it contracts. And sometimes there would be arbitration agreements that are unconscionable, or like, for example, we have cases where the amount that would be involved is something like 20,000 pesos or 50,000 pesos, but the institution is PDRC. And in PDRC, immediately a party who will file a case will be required to pay 200,000 pesos already. And so there's something wrong with the contract. And of course, here we are talking about the parties, the inequality of their situation. Then, of course, lack of consent. Well, this is easy, and I don't think that we need to discuss this very long for the mistake. Lack of capacity, let us just take note, the capacity is governed by the national law of the parties. And so, when we are talking about lack of capacity, then we look at the law governing the personal law rather of the parties to the contract. Then we have inoperative, well, termination. Of course, if it's already terminated, then this does not exist anymore. Waivers, well, generally when a party enters into this instance of the dispute in court proceeding, then necessarily the result will be a waiver of the right to demand arbitration. Changed circumstances, well, this is a bit hard to prove because this means that there was a change in circumstances and the parties are no longer, or one of the parties maybe, is no longer in the same situation. Repudiation, again, this requires the consent of both parties. Only one party cannot just repudiate. Inconvenient arbitral seat, this is generally not favored, but again, we're talking about a situation where the arbitral seat may be, let's say, very far, and the amount involved is so small. Like, for example, the arbitral seat is, let's say, Kiribati or one of those islands in the Pacific, no? Incapable of being performed. So here it's impossibility and similar defenses. Now in the Philippines, there is this law. This is a very, very old law. And this has not been amended somehow. If the parties fail to agree in writing, this applies only to domestic arbitration. If the parties have not agreed on the fees of the arbitrators in writing, then the default amount is 50 pesos a day. That's about $1 US. And we're talking about a situation where if it were a tribunal, all of them will have to share that $1, and necessarily, of course, that is incapable of being performed. Now, what is really contentious would be in the Philippines, at least, is the principle of, well, arbitrability, no? As a general proposition, all disputes are potentially arbitrable in respect of any defined relationship, whether contractual or not. Now, some disputes, however, are generally recognized as inherently not arbitrable. Like, let's say, for example, we have the validity of marriage, liability arising from crimes, also status, and they are basically not arbitrable. Others are not arbitrable by law. So the justification is that each state is supposed to decide, or each state decides which matters may or may not be resolved by arbitration in accordance with its own political, social, and economic policy. In the Philippines, there is this issue about construction arbitration in the Philippines. Under Philippine law, construction contracts, right? If there is an arbitration agreement in a construction contract that was being implemented, or to be implemented in the Philippines, then the Construction Industry Arbitration Commission will have exclusive and primary jurisdiction. This is regardless of the agreement by the parties to select another institution. Like, for example, they selected PDRC in the Philippines. So that will not be valid, the selection of the institution. At the same time, the applicable law would immediately be Philippine law or Philippine construction law. So as I have said, there is an issue here, and this is the defense of the CIICA, that it is the decision of the Republic of the Philippines to take up arbitration disputes from arbitration. Okay, and it is said that the resolution of the excluded disputes are reserved to courts and specialized bodies. In what we are talking about, construction, then it is the Construction Industry Arbitration Commission. And the opinion of experts is that the exclusions are enforceable by courts even if it's in another country, if backed by statutes. So that is just an example of a non-arbitrable dispute, so to speak, in the Republic of the Philippines. So then we have pathological clauses, an agreement that will hamper or defeat the constitution of the tribunal or invite court intervention is so-called pathological. No? And agreements that are muddled, unclear, or incomplete, such that it is not effective to cover all the disputes that the parties intended to submit to arbitration, are so-called pathological clauses. So we have the one-off clause in international ad hoc arbitration agreements. So quoted, all disputes arising out of the present contract shall be settled by way of arbitration. Now, if this were an international contract and there is no seat of arbitration, there would be difficulty in constituting the tribunal in case of recalcitrance, because there is no indication of the law that will apply to the arbitration or any competent authority that may be called upon to assist. Of course, institutional rules normally provide a solution to the problem. Like, for example, in ICC, it will be the ICC court who will determine the seat of arbitration in the event that the parties fail to stipulate on the seat of arbitration. Then we have the imprecise or false designation of the arbitral institution. Again, some examples. Any dispute or contravention of the present contract shall be submitted to the French Chamber of Commerce of Sao Paulo. Of course, there is no French Chamber of Commerce of Sao Paulo. Then the same, almost the same, no? In case of no amicable settlement, all disputes that may arise shall be settled pursuant to the arbitration rules of the International Chamber of Commerce of Singapore. As we all know, the ICC is in Paris. No? For this one, any dispute arising out of the present contract shall be submitted to arbitration to be administered by the Philippine Chamber of Commerce and Industry under its rules that are presently in force. Now, the problem here is that the Philippine Chamber of Commerce and Industry is not an arbitral institution. Although there was a time when PCCI was, well, shall we say, an arbitral institution. But its dispute resolution arm is now the Philippine Dispute Resolution Center. We have internally contradictory agreements, like the arbitration shall be seated in Miami, but the seat of arbitration shall be at the ICC in Paris. And as we can see here, there are two seats that are stated in the arbitration agreement. The rules shall be ICC rules to be administered by the SIAC. Now, what happened here was that the Singapore court ruled that this is valid, all right? And so ICC changed its rules. So right now, under ICC rules, only the ICC can administer ICC rules. So there will be a problem here. Then we have agreements that appear to provide for both arbitration and litigation. Now here, I think we have to look at the language because this may just be a venue provision, in which case the party initiating the case or dispute will have an option. The same rule designating two or more arbitral institutions. But in these two cases, necessarily, this will involve court intervention in order to find out what really is the intention of the parties. Then again, we have the optional or non-mandatory agreements using the word may or giving the parties an option to either arbitrate or litigate. But as I have said, this may be treated just as a venue provision depending on the wording used by the parties. So this calls for court intervention. All right, so that's I was given a very short topic.
Thank you,
So
Mr.
that's it.
Valderrama. Those were very insightful comments. So I think one of the key takeaways for not just lawyers, but for any law students who are watching this is that to avoid disputes in the first place, you should be very clear and precise and concise with how you draft the arbitration clause, because that lays the foundation for your entire relationship. And if there's any imprecision, any ambiguity, that could cause complications going forward. So of course, that is very important. So thank you once again for your comments. Moving along to our next panelist, Mr. Phuntsho Wangdi. He will be talking about the choice of language in cross-border arbitration and the challenges brought by using a foreign language in arbitration. Mr. Wangdi is an advisor to the Thai Arbitration Institute, Office of the Judiciary. He has an honors from English honors from the University of India, postgraduate diploma course in national law from Royal Institute of Management, Bhutan, Bachelor of Laws from the University of Mumbai, Bachelor of Laws from the University of Mumbai, Masters in Comparative Law from the University of Adelaide, Australia, and Mannheim University, Germany. Mr. Wangdi, the floor is yours.
Okay, Sir Rana, thank you so much for the very detailed description about me. And I would also like to thank Jian, Beijing for giving me this opportunity. I was supposed to give a talk on this in the previous webinar, but since the panelists were full, I didn't get a chance. But anyway, I've given second chance. Thank you so much for this. And I would like to also thank all on behalf of Thai Arbitration Institution from Thailand. So I've been given this topic on the choice of language in cross-border arbitration and challenges brought by using foreign languages in arbitration. So this seems to be a very interesting topic, because language is one of the most important factors in every arbitration, because especially in the international arbitration, because as international arbitration is a transcultural venture, it is important to bridge the language and linguistic differences. That's very important because people of many culture, custom, traditions, and all these scenarios will make a big difference if language is not made very clear. So if such issues are not resolved from the beginning, so I think from the very start of the arbitration, from the very beginning, the language has to be, the problem on the language has to be resolved. Because if it is not done, then it will delay the arbitral proceedings and which will ultimately increase the cost of the arbitration. So that's why language is very important. So although arbitral tribunal can decide on the language of arbitration, they have this competence if things are not clear. But at the same time, I would also like to suggest that it would be viable for the arbitral institutions to specify certain provisions on the language of the language in the rules, because sometimes the parties may not agree, and then parties may not agree with the tribunals, and sometimes there may be also some problem among the tribunals members. If that is the case, if there is some sort of it went out in the institutional rules, I think that will also give a vain means of solving the problem. So that's why I think for institutions also, if they also give some of these provisions, then it will help. Then it is important for parties actually to agree on the use of language while drafting the arbitration agreement. This is what I've already suggested before. Then just to cite one example under our Thai arbitration institution rule, that's Rule 10. It's regarding the issue on the language. So Rule 10 provides as follows. Where the arbitration agreement does not provide for the language of arbitral proceedings and the parties have not agreed otherwise, the statement of claim, statement of defense, and counterclaim shall be in the language used in the arbitration agreement. So this is especially in the initial stage before the case reached before the arbitral tribunal, before the arbitral tribunal is formed, when there is an issue of language, then I think the institution can always make a decision based on the language that is used in the arbitration agreement. Where the arbitration agreement provides for more than one language, sometimes parties give more choice to be used in the arbitral proceedings, then the parties have submitted their SOC, SOD, and counterclaim and answer to counterclaim in one of the languages, since they have a choice. Then in that case, the institution may order the other party to submit a translation of the documents in another language which are specified in the arbitration agreement. Sometimes if there is some problem from the other side of the party on the documents submitted by one party, then the institution can always pick up one of the languages which has already been agreed among the parties. And then the institution can suggest the particular party to do the translation in that particular language which are included in the arbitration agreement. So based on the party autonomy in international arbitration, language can be agreed upon by the parties through choice of language, which has great implications on the parties' position in the arbitral proceedings, actually especially for the convenience and cost of arbitration. Therefore, if parties have already agreed in the use of language in the arbitration, the arbitral tribunal will have to accept the determination. So when the languages are very specifically mentioned in the arbitration agreement by both the parties, I think the arbitral tribunal will have no discretion to choose some other language. In that case, I think if we do that, then parties might later challenge on this, by not respecting the party autonomy. So for that, I think even the arbitrators have the responsibility to make a decision whether to take the case or not. When the languages are specifically given in the arbitration agreement, if they are not conversant on that particular language, I think then we as arbitrator cannot take up the matter, because later on there will be a problem. So as many parties from different countries are involved in international arbitration, under Article 17(1) of the Universal Arbitration Rule, it provides that the arbitral tribunal shall determine the language of the arbitration immediately after the appointment. Such procedures should also be followed even if procedures are not conducted under Universal Arbitration Rule. So if the language is not yet decided in the arbitration agreement, if it is not there, then soon after the appointment and formation of the arbitral tribunal, they must decide on the language. That is the first thing which is very important. While declaring the language, it is vital for arbitral tribunal to consider legal and practical issues which will have implications while making decision and enforcing the arbitral award. So when the language has not been specified out in the agreement, and now after the formation of the tribunal, if the arbitrators will have to decide on the language, then in that case, I think it's very important for the tribunal to really look into the interests of both the parties and also the legal implications and practical issues. So I think choosing a language later at the later stage before the arbitration and then before the arbitral tribunal is very important, because once you have chosen the language, it's going to give greater impact, and then such will have a rippling effect on the making of the decision and later even in enforcing the arbitral award. So for this, here I think the arbitrators will have a great responsibility in making a right choice of language, which both parties will abide by. Then the language of the contract document and correspondence between the parties are important references as it indicates the convenience of the parties. So when choosing the language at the arbitral tribunal, I think there are many ways and means of deciding on the language. So one of the factors is that the arbitrators might have to look through the prior correspondence between the parties. These are important references, and also the nationality of the parties. Because if the parties have been doing correspondence in English, then I think this is an indication that they are quite comfortable in that language. Or sometimes we can also look into the language of the arbitration, and also the nationality of the parties are very important, so that both parties will get benefit of choosing a language with the arbitrator. The other thing is the cost. The costs involved in translation of oral proceedings and written submissions are a matter of concern. So that's why we always say that if sometimes in the arbitration rules, regulation, even in the acts, sometimes there is a provision for default language in the rules. And in that case, when the parties have not really decided on the language in the agreement, but rules provides for a default language, then even in that case, when the arbitrators are given the offer of arbitrating, they'll have to choose whether they can take it or not, because that rule will apply. The determination of language may impact the fundamental rights of the parties. So that's why I'm saying that arbitrators will have to choose the right language, agreeable both the parties. Otherwise, it's going to impact the fundamental rights of the parties, and especially the right to be heard and treated equally will not be respected, and parties are likely to challenge the award, because this will be the breach of the provisions of the New Convention. Therefore, in international arbitration, especially, language cannot be considered as secondary matter. Language is one of the primary matters to be taken as a matter of concern by both the parties initially, if not later, the second stage by the institution before it goes to the arbitral tribunal, and later at the arbitral tribunal when they decide. If they have to decide on the language, they have to consider it one of the primary matters, as it can potentially affect the arbitration in many dimensions and would delay in the arbitral proceedings. So sometimes you know that before the arbitral proceeding begins, to determine the language, it takes a lot of time, just a lot of time, and that will be a waste of time and money. Although English is the dominant language in international arbitration, it cannot be the sole language at all times. This is because people who pretend to master over the English language can sometimes be badly affected by the language deficiency. So just by mere that one person can talk English doesn't give any guarantee that he would be able to deal professionally during arbitration. So there are also other languages like Chinese and French are now becoming popular. So the other language should also be given equal importance based on the need of the parties. Then other thing is that parties can appoint arbitrators and legal counsels, which includes English speakers and speakers of other languages as deemed appropriate. So when the parties are planning the arbitration by signing an arbitration agreement, I think it's quite important that they cannot simply sign an arbitral clause and include in the contract, or just only simply agree in this arbitration. Otherwise, you know that later on there will be a lot of ambiguity. So arbitration agreement has to be detailed, and even they have to go to the extent of even appointing what sort of arbitrators they want, the qualification of the arbitrators, the language efficiency of the arbitrators, and what sort. They'll also have to plan on the legal counsel, what sort of legal counsel they want to have. So then how many languages do you need in this? So if such things are not planned well beforehand, when problem comes, then you know once the parties are at loggerheads, they'll not be able to agree to each other, and that will be a waste of time and give a lot of the difficulties to the institute and even to the arbitrators. So English-speaking arbitrators cannot be fully determined through citizenship and passport. This is because identification by no means can guarantee perfect English language skills if English is not the native language of the individual. So that's why I think proper determination by the institute, by the party, and also the declaration by the arbitrator itself on the language is very, very important. Option to choose many languages will give, actually, is very good because it will give the flexibility and knowledge of first-hand experience of different legal cultures, and such must be the key principles in cross-border arbitration. So, for example, even BRI arbitration cases, I think we have to give a choice of language. It's very important, which will ultimately give the flexibility. For efficiency and time saving, it's better to have international arbitration team composed of native and non-native English speakers. It will all based on the nature of the case. So it means the nationality of the parties based on that, and what sort of witness are they going to prepare for the case and all that thing. So that's why I think there has to be a choice of language, which will give the flexibility. So just want to set an example. It will be good to cross-examine the Russian witness by the Russian counsel rather than by the native English speaker, though Russian witness can speak English language, because he may not have that confidence when he is being cross-examined by the native English speaker. The issue of misunderstanding between the parties due to use of inconsistent language for correspondence could lead to complications, which may take long time in resolving the matter. So here I just want to cite one example. This is a case between CEG, Shanghai base, versus Lumos, US base, where US Court of Appeal for 10th Circuit upheld a US District Court of Colorado's decision, which declined to confirm a Shanghai International Arbitration Center's award. This is because the notice of commencement of arbitration sent to the US respondent was in Chinese rather than in English, which is contradictory to prior communication between the parties where correspondent was in English. Even they have also decided English to be the language of arbitration. Therefore, the notice in the Chinese language was not reasonably calculated to appraise lumos of the arbitration proceeding. This is because the notice of the commencement of arbitration sent to the respondent in US was in Chinese rather than in English. This is contradictory to prior transaction between the parties where English was to be used as a means of communication. Therefore, the notice in Chinese language was not reasonably calculated to appraise lumos of the arbitration proceedings. They were not aware that they have appointed arbitrator on their behalf and it has comments. So generally people spend more on arbitration rather than on interpreters, which actually is very important, preparation of the interpreters if required. Therefore, it is important to engage professional interpreters to convey the right meaning at the right time. So that's why even choosing the interpreters, I think we have to do a lot of assessment. So preparation of interpreters before the hearing is vital. So that's where the interpreters, when interpreters are engaged, I think the legal counsel or the parties should brief him or her well of the matter. So that's where that he or she gets also gets the right information of the overall view of the case, and that while interpreting it will be easier for him. So for this, parties must be willing to, of course, they have to spend money. For example, a witness who is not English native speaker may face challenges if cross-examined by English native speaker. Therefore, the counsel who speaks the native language of the witness must be engaged if possible. Otherwise, the witness might inadvertently make mistake, which could lead to unjustifiable advantage to the other party. And that should not be encouraged. The arbitral tribunal must be cautious. They have a very noble duty to be cautious when witnesses do not testify in their native language, especially. This is because the case could be decided on the misunderstanding of certain meanings of the word in foreign language. And this could be later debated and will be a waste of time. It must be ensured that one party does not take advantage over the other who has deficiency of the language of arbitration. That, I think, the arbitrators must ensure. It's also important for counsels to clarify things when their witness misunderstands certain legal terminologies or language. If the witness make any mistake, then I think it's very important for counsel to clarify things before the tribunal. And for this, the tribunal must also be lenient to the witnesses who speak foreign language while testifying in evidentiary hearing. There has to be flexibility in such a case. If the parties and arbitrators fail to decide on language of arbitration, the arbitral institution shall take lead role to decide on the language in the initial stage while they're making the submissions. And that's why I also said that there has to be a certain rule in the institutional arbitration rules. Where institution fails to appoint the arbitrator, actually who otherwise would be deciding on the language. Sometimes the arbitrator, sometimes the case goes from the institution to the for the arbitration, and when the arbitrators are not being appointed, then that who will in fact decide on the language? Then that thing, the matter will have to be taken before the court, which will holistically review the case and appoint arbitrators. So when many parties are involved in the business transaction, bridging language differences, therefore, is very important, especially for the success of arbitration. If such things are not resolved from the beginning, it can lead to costly consequences. So parties usually negotiate among themselves to choose either their languages or other languages. The general trend is that people choose English, which is not the native language of either of the parties, which means that English becomes a lingua franca, a language that is adopted as common language between parties whose native language is in fact different. The issues of language will also now arise in our BRI arbitration, as it involves around 140 countries. I don't know if it's right or not, but this is what I get information from the resources, and which makes around 65% of the world population. So that's why, in these languages, very, very, very important. As activities are already initiated, there will be challenges for investors, contractors, and service providers, as contracts will be carried out in various jurisdictions where litigation, arbitration, recognition of and enforcement of court orders and arbitration hours would be complex. So in BRI, it's very, very important to decide on the language. As many countries are involved under BRI, there are at least like 53 official languages, out of which only 20 is taught in foreign language majors at high school institutes. So therefore, there's very less choice. So therefore, choosing language is very important. Therefore, choosing relevant language for arbitration by the parties from the beginning is crucial, which would give fair deal to both the parties. So, but the positive point on BRI is that because there are 92% of the countries under BRI are under signatories of New York Convention, which offers reciprocal recognition and enforcement of arbitration award between contracting parties. That's good part of it. Therefore, obtaining an award from arbitral tribunal in a convention state, which is to be enforced in another convention state, will minimize the risk of avoiding local laws related to enforcement. Therefore, BRI arbitration agreement must be carefully drafted as any other arbitration or included as arbitration clause in a contract, which ensures that the dispute to be resolved by the arbitration institution under their arbitration rules or even on ad hoc basis, which will minimize resolving disputes in less favorable local courts under BRI. So we must always try to avoid courts as far as possible. So this is what I have to say on a very short note. And I'd like to thank once again for giving me the chance of making this brief presentation on the language. Thank you.
Thank you, Mr. Wangdi. It was very comprehensive and very insightful. So just underscores the importance of specifying the language of the arbitration. A lot of times people take this for granted. I mean, the understanding is that you're communicating in English, so proceedings would also be in English. But sometimes that could be a bone of contention and possibly another dispute that needs to be resolved. And as good lawyers, of course, we need to minimize the sources of disputes. So I think it's always advisable to actually specify the language of the arbitration. And as you rightly mentioned that, there are about 53 languages spoken across the BRI geographic sphere, which basically means that, there could be so many misinterpretations of what the arbitration language is going to be. So all the more reason for parties to be mindful of this particular issue. So thank you very much for this.
Thank you.
So just a reminder to the audience members, all of you, please feel free to send in your questions. We will be taking those questions towards the end in the Q&A session, right before we wrap this up, because we don't want to disrupt the entire flow, because some of the questions being sent in are not relevant to the particular panel discussion, but feel free to send them in, and we will try to ensure that all of those questions are posed to the relevant panelist. Thank you. So up next is myself. I'm actually in this unique and rather privileged position of wearing two hats today. I am a moderator of this webinar, and I'm always also been invited to speak on a topic. And I don't know how to do this, but I'll do the introduction myself. I'll keep it brief. My name is Rana Sajjad. As you may know already, I'm a Pakistan lawyer based in Pakistan. My law firm's name is Rana Jaz and Partners. Our practice areas include commercial contracts, domestic and international arbitration, cross-border transactions. I'm also the president of the Center for International Investment Commercial Arbitration, CIICA, which is Pakistan's first international arbitration center. So international arbitration is something I've been very passionate about. CIICA was set up about 6 years ago. And we've come a long way in terms of building capacity, raising awareness of international arbitration in Pakistan. We've organized several workshops, conferences. We're working on reforming Pakistan's legislative framework as well. And of course, we're offering arbitration mediation services. And this CIICA's introduction is also relevant to my talk, which I will try to keep brief, because although the topic I'll be addressing is the China-Pakistan Economic Corridor, which is the Pakistan component of the BRI, the disputes under this framework, I think, is something that I'd like to focus on as well, because that is in line with the theme of this particular webinar as well. So I'll start now. So CPEC, the China-Pakistan Economic Corridor. Now you utter this word in Pakistan, and it evokes different kinds of emotions. Mostly people get very excited about it because for the longest time, China has been a dear friend of Pakistan. There's actually an interesting expression which says that the relationship between Pakistan is deeper than the deepest ocean and higher than the highest mountain. And some even say it's sweeter than honey. So that's how much people in Pakistan value the relationship, the friendship with China, which is why all this investment coming into Pakistan has a lot of value. And it's also a very delicate matter. A lot is riding on this investment. Pakistan's economic progress, if I may, is also resting on this project, because it's a huge initiative on the part of China. At this point, it's estimated to be around 65 billion USD, which to put this into context, this is about 1/5 of Pakistan's GDP. So in that sense, it's a substantial investment coming into Pakistan, which is why a lot of people want to make sure that everything goes smoothly. There are no unnecessary disruptions, obstructions, delays, which is why this is hotly discussed, debated, Some people have some controversies about it too, but for the most part, people in Pakistan are very happy about this because it signals, the interest of China and Pakistan and the welfare of the Pakistani people in general. Now, so what exactly is CIICA? CIICA is actually a collection of different infrastructure projects. It includes railroads, highways, power projects, dams, wind power, solar projects, and special economic zones, SEZs. So it's a fairly comprehensive initiative on the part of China. Now, the crown jewel of CIICA is the Gwadar seaport in the south of Pakistan. Now, according to different estimates, now Gwadar provides a very viable transit trade route to the Chinese, as opposed to, let's say, the Southeast Asian option. If they use the Gwadar port, that will save their traders, their businesses a lot of time and money. So, which is why the Gwadar port, in which China has invested hugely, has a lot of strategic value for the Chinese and for Pakistan, of course, because for the longest time this wasn't developed. So that is something where essentially the CIICA culminates. That is the end of this corridor. The Gwadar is basically sort of the end point of this project. But of course, along the way, there are very important projects, and so far most of the projects relate to power generation. Now, power generation has been a major problem in Pakistan until 2-3 years ago. We used to experience major power outages here in Pakistan. The industry, especially the textile industry, one of the largest exporters or source of exports in Pakistan, took a big hit because of those power outages. Thankfully, because of these investments and some initiatives on the part of the government, that problem has been resolved to a certain extent, which is a huge relief for Pakistanis, whether it's residential consumers or businesses, commercial users, because of course without power you cannot expect economic progress. So CIICA, a large part of it is power projects as well. Roads, highways, railroad, of course, it's a big part of it as well. And our bottom line is you develop a country's infrastructure and that lays the foundation for the country's economic prosperity. Now, we won't get into the debate of what comes first. Do you have to take care of the health and education or infrastructure? I think that at times becomes secondary, because infrastructure is the cornerstone on the basis of which a lot of countries build their progress. So the fact that we're doing this with the help of the Chinese, a lot of people are grateful to the Chinese for doing this, because Pakistan has been dependent on foreign aid, unfortunately, for a long time, from different international financial institutions. But we now believe that the CIICA is a blessing for Pakistan, and hopefully we're able to sustain this and ensure that all projects are completed on time in a smooth and friendly manner. Now, about the disputes. Now, so this is a bit of a mystery to some people. As a practicing lawyer and in the capacity of head of an arbitration center, the nature of disputes sometimes it's not very clear. Like a lot of people ask me, so what kind of disputes are arising under the CIICA framework? Sometimes I cannot put my finger on it. What kind of disputes? Of course, you read the news reports and you hear about this railway project being disrupted because of a dispute with the government on, let's say, the interest rate to be given on that funding for that project. And then you hear of this national grid, power grid organization has a dispute with the Chinese company over certain guarantees. Now, these are very high-profile disputes, and we hear about them in the newspapers. But eventually, and thankfully, they're amicably resolved. I can speak from experience. I cannot name the companies or specify the dispute, but I was contacted by a huge dispute, again in the billions of dollars, involving a Chinese company and the Pakistani government entity recently. And the idea was that the Chinese company, they were thinking of arbitrating the dispute. But we found out through a very reliable source within the government that had been amicably resolved. So everybody was happy about this, because of course nobody really benefits, especially in a delicate situation like this, from spending a lot of money, especially when the government entity is involved. So thankfully that did not happen. So, but these are the high-profile disputes. What about the mid-level disputes, the lower-level disputes, the smaller disputes with the vendors, contractors? Because all projects, all disputes don't involve billions of dollars, right? There's millions of dollars, hundreds of thousands of dollars as well. There's different types of disputes. How are they being resolved, or how will they be resolved? Again, there is no clear question to this particular, clear answer to this particular question. Now, there's different options, of course. First and foremost, of course, is international arbitration, which is a viable method which is generally accepted. And in that, I'm actually pleased to share with you all that CIICA, the arbitration center I've set up, we signed an MOU with the Hangzhou Arbitration Commission back in 2017, which was the first MOU between the two arbitration centers from China and Pakistan. 2 years later, in 2019, I was in Beijing to attend the China Arbitration Week, and the CIICA signed a cooperation agreement with THAC, which, as you all know, is the largest arbitration institution in China. And of course, one of the terms of the MOUs is that in case of a dispute, both centers will jointly administer the arbitration proceedings, which is great. But again, it does not happen that often. And I think the critical issue there is, how do you inform the users about the availability of such mechanism? Of course, you could go on social media, you could even publish a news report about it. But how will that mechanism actually play out, pan out for users to understand? That sometimes is the tough part. And then the other is, of course, a lot of investors are still okay, surprisingly, with going to local courts. Now, in Pakistan, recently, they launched these commercial courts here in Punjab, the province where I'm based, which is Pakistan's most populous province. Now, the launch of the commercial courts is, again, great news for foreign investors. But of course, these courts are new. And although the judges are trained, they have a certain mindset, they're very progressive. They want to expedite proceedings and all that. But it's not easy to convince foreign investors right away about the viability of this mechanism. Besides the commercial courts, of course, we also set up these mediation centers across courts in Punjab. The government took that initiative, which again is a good initiative, because mediation, as you all know, is getting off the ground, especially in China and Asia in general. It's widely accepted. Sometimes it's even preferred over arbitration. So setting up those mediation centers is also a very welcome development. But then again, who actually is administering disputes there? Are those people trained? Do they have experience, expertise? In some cases, it's not. Again, so is that a viable option for resolving CPEC disputes? Possibly not. The other option is, of course, having a joint center, perhaps like the one China has with South Africa. And I understand that the idea is basically all the disputes related to China and Africa in general, and South Africa in particular, would be resolved by that joint arbitration center. Now, again, that's a fantastic idea, but I think it's very rare, though. I don't know of many centers which operate like this, but perhaps something like this for Pakistan could work too. Because again, we have a history of very good relations, and if parties from both sides, Chinese investors and local private businesses or government entities, know that both countries are involved in this, it's not one country's initiative, that could probably give it more neutrality, more credibility. So perhaps that is also an option for CPEC disputes. And now the clock is ticking, frankly, because the CPEC was officially announced in 2013 and officially launched in 2015. So it's been 6 years since it formally started. And the deadline has actually been extended. Now, from what I know, this will go on till 2030, which means another 9 years. Now, 9 years seems like a long time, but I think when it comes to foreign investment and for a project with 6 years have already passed, it's not a very long time. So unless the disputes are being amicably resolved, I think both states, perhaps, or private institutions, arbitration institutions, should step up to the plate and discuss, to make this system sustainable, to ensure, because, a lot of times investment comes in and there's a lag between the investment and the arising of the dispute. Investment, let's say, was made 3 years ago, the dispute could arise 5 years later, right? So just because things have been going smoothly so far does not necessarily mean they're going to go on like this. And I think there's no need to be skeptical and pessimistic, but you need to be realistic, because if there is a big dispute or a series of disputes which cannot be amicably resolved, and there are no viable mechanisms that are mutually agreed by the parties, it could only undermine the entire credibility of the project. So I think there has to be serious conversation about this to make sure that there are acceptable methods for parties to resolve these disputes. And of course, we do Arbit, CIICA, the center we set up, we try to organize workshops and conferences on a regular basis to discuss these topics. We try to get government officials involved as well. We've had Chinese speakers also, but I think this is an ongoing process. And also, I think we talk about the Belt and Road, and although this is the Pakistan component, but a lot of people think this is the flagship project for the Chinese as far as the BRI is concerned, because this is one of those projects which some people think started even before BRI was officially launched. So it is critical in a lot of ways, which is why I think the mechanisms still need to be discussed. Again, all the issues that we discussed so far, the choice of language that needs to be specified, I think, of course, it applies here as well. Validity of the arbitration agreement, and of course, what is stipulated in the clause. What is the seat? So I'll give you an example. I was told by a lawyer that there are some Chinese companies which are stipulating a domestic arbitration clause under which disputes shall be settled in an ad hoc manner by ad hoc arbitration under Pakistan's arbitration law from 1940. It's called the Arbitration Act 1940. So to put this into context, Pakistan came into being, Pakistan was created in 1947. So 7 years before Pakistan was created, this law was passed. It was given to us by the British. It has not really been updated or modified yet. And so it's a bit surprising that some foreign investors actually are okay with having a clause with an arbitration law from like 80 years ago, which could mean two things. Either that this system works very well for the foreign investor, or it means that they don't really rely on this mechanism. In a lot of cases, the disputes are either amicably resolved, or the foreign investor just chooses to resolve it in the way they prefer. Let's say they go to their local courts, or they go back to their own country. And then, of course, there would also be issues with enforcement of the award, whether in Pakistan or China as well. So the seat of arbitration needs to be specified as well. You can't just take it for granted that you'll have Islamabad or Lahore or Karachi as the seat, or let's say Beijing as the seat. Ideally, it should be a neutral seat. So that needs to be discussed as well. So there are a lot of things which businesses here don't discuss. We thankfully do have a Pakistan-China Joint Chamber of Commerce and Industry as well, but I'm not sure how much progress they made in terms of getting through to foreign investors or the Pakistani businesses involved with the Chinese in educating them in how these need to be resolved. But I think it's only a matter of time before which it will be very obvious to people that there should be a sustainable mechanism for resolving these disputes. As I said, CIICA is doing its bit. We're going to continue building relationships with Chinese entities. Of course, we have one with Zizong as well. And as I mentioned at the start, they've done a fantastic job of raising awareness of arbitration, especially in the tech space. Technology is the future. Actually, not really the future. We are actually living in a day and age when technology is a very important part of our life. So of course, online hearing, virtual hearings. There's also talk about blockchain arbitration. So a lot of these things need to be explored within the CPEC framework in particular, and I think BRI in general. And on that note, I think I will close my talk. And of course, if there are any questions, of course, you can send those and we'll address them in the Q&A session. Thank you. I'll take off my speaker hat now and put my moderator hat back on. And I'd like to invite our next speaker, Mr. Nour Sharif, who will be discussing multi-party contracts, international arbitration. Mr. Nour Sharif is an international arbitration lawyer based in Cairo, Egypt, and off-counsel at a law firm in Kenya and Nigeria, and he specializes in international mediation. Mr. Sharif, the floor is yours.
Before we're going to start, I would like to thank you, Mr. Rana, and I would like to thank the whole panelists. And I would like to thank Beijing Jian technology company for inviting me. It's a privilege to me to be with all of you today as a speaker in one of the most topics really interesting and Belt and Road Initiative. And also participating with ultra elite lawyers and arbitrators from all over the Asia continent. Before we're gonna start, I would just want to know, is everyone can see me and hear me well?
Yes, we can hear you.
Okay, great.
Yes.
Okay. Today, my presentation is about multi-party contracts and international arbitration. And moving to the next slide, gonna be the content of the presentation, gonna be like Belt and Road projects. And the second thing, gonna be what is multi-party contract? And moving to the third point, is gonna be what is multi-party arbitration? And the fourth, gonna be an overview on international institutional arbitration rules, and finally gonna be the conclusion. I would like to know, and I would like to start with Belt and Road. What is Belt and Road in general? Belt and Road is one of the largest infrastructure investment projects in the history. It is very complex and high value and high public interest and long-term capital incentive and multi-contracts and cross-border projects. And also it cooperate between Belt and Road countries along with Belt and Road countries in many different areas such as infrastructure investment and also international trade, sale of goods and construction and railway and highway, automobile and power grid and for sure. Then I just want to express from where the multi-party will arise in the future. There's a lot of countries participating in Belt and Road initiatives. There is a lot of parties will participating in international contracts, investments, energy, construction. Then I would like to move to the next slide. Let's know what is multi-party contracts. As we see on the slide, multi-party contracts include one or more promise or a contract commitment, which is a commitment to perform certain action which could be performed by multi-parties. Those actions can trigger, involve, and finish the commitment. And in multi-party commercial transactions, a contract violation can be caused by a set of action, which can be caused by direct and or indirect contractor parties. Moving to the next slide. Okay, one of the main things happened when the commercial contracts or multi-party commercial contracts has been breached is two main issues between international parties or even two parties. First thing is the consolidation issue, and the second thing is the joinder issue. Let's know what is joinder and what is consolidation. Joinder, as we see on the screen, it shows that joinder is adding one party or more to the existing arbitral proceeding, as if any kind of the parties want to join any kind of the hearing, arbitral hearing, he have the ability and right to show his disputes and to avoid the parallel arbitral proceedings and multi arbitral awards. Then the main important of the joinder and consolidation is to avoiding the multi arbitral award and multi arbitral proceedings. Then let's move to the next slide and discover what is consolidation. As we see, consolidation simply is joining the multi-existing arbitral proceeding. So both joinder and consolidation is joining the existing proceedings, and it depends on how the parties want to join, like we see on the screen. Simply, what is multi-party arbitration? As we see, multi-party arbitration is related to the situation in which there are more than two parties in the contracts. And in this situation, the key issue can arise is the need to ensure that each party, regardless how they are, have the equal treatment and rights in the formation of the arbitral tribunal and through the arbitral hearing, arbitral proceedings, as they can show what they want to show to and they want to discuss related to the disputes to the and before the arbitral tribunal. Multi-party and multi-contracts is really and very complex disputes, and actually it existing now in all over international arbitration practice around the globe. This is not surprising at all, given the increasingly of the complex nature of the international trade, and not also in international trade in many different areas, international investments, and also it arises in commercial transactions, as we said, and also in construction arbitration. Moving to the next slide. Multi-party arbitration. As we all of us know that the international arbitration have a specific feature which make this method is totally special through the whole ADR mechanism, as it have international arbitral award, which is enforced in many different countries, really, which are part of the Nour conventions, and is impartial and confidential method, which is allow the both party to choose the arbitrators who are gonna says the final word in the international arbitration disputes. International arbitration is one of the most methods which have the ability and the power also to resolve the multi-party contract disputes. As multi-party disputes became now more and more common, and arbitral institutions around the globe now have begun to recognize the importance of including the joinder and consolidation provisions or rules to overcome any kind of difficulty. As I said before, difficulties related to the multiple of the arbitral awards or multiple arbitral hearings. I would like to show an overview on institutional arbitral rules related to the joinder and consolidation provision in their rules. First, gonna be International Chamber of Commerce, ICC. The new rules provide articles for consolidation and for joinder. For example, we do have Article 7 related to the joinder of the additional parties, and Article 10 for consolidation for arbitrations. Next is Hong Kong International Arbitration Center. They provide Article 27 for the joinder and also Article 28 for the consolidation. Next is gonna be LCIA, London Court for International Arbitration. Within new rules, 2020 rules, they provide Article 22 for consolidation and joinder. Next slide gonna be CIICA is Singapore International Arbitration Center. They have and provide Article 7 for joinder and Article 8 for consolidation. We have also Shanghai International Arbitration Center, CIICA. They also provide Article 31 for joinder and Article 30 for consolidation. And my conclusion gonna be, it's important for investors to have the right tools to manage any kind of risks related to Belt and Road opportunities, as international arbitration, with its many benefits and advantages, it should be on the top of the party's mind, is the most method as international parties they have to think about as its preferred method of dispute resolution mechanism around the globe. And now, with a variety of the international arbitral institution preparing for the chair for the Belt and Road Initiative, BRI, dispute resolution pilot, parties are well advised to study the arbitral rules of the different arbitral institutions carefully, as well as the law of the seats where the arbitral institution commonly operate, to fully understand the advantage and disadvantages, pros and cons of choosing any precisely or particularly arbitral institution. And this is very fundamentally an important successful risk management for any future Belt and Road projects. Thank you.
Thank you, Mr. Sheriff, for the insightful comments. And of course, you've highlighted a very important issue, multi-party contacts. And of course, for a project like BRI, I think it's highly likely that we come across such issues. So I think lawyers and parties should always be prepared for such a scenario. So I think, yeah, these are very helpful comments. We were hoping to have one more speaker, but I think unfortunately he's unable to join us, possibly because of some technical issues. So that's it for all our panelists. So now we will open it up for questions. We've already received some questions, and I'll start with those. In the meantime, members of the audience, please feel free to send in more questions. We'd be happy to answer as many as possible. And of course, even I would also request the panelists, if you have any questions for each other, I'd be happy to have that discussion as well. But for starters, I will start with the questions sent in to us by the members of the audience. Now, the first question is how the difference should be drawn between the formal and substantive validity, where both play a fundamental role on applicability of arbitration clause for pro-arbitration regime. Now, this question addresses the validity of the arbitration agreement. So if I may, if Mr. Mario Valderrama wants to answer this question, that's perfectly fine. And of course, any of the other panelists can also answer this question. But if Mr. Valderrama wants to go first, basically, if I understand this correctly, the question is between a formal and substantive validity, what is more important? So I think the question essentially indicates that if the clause has not been drafted in a very clear manner, and let's say very informally, how does that affect its validity when it comes to its interpretation in a pro-arbitration regime? So any of the panelists or Mr. Valderrama?
As we all know, the New York Convention requires that it should be in writing. No? I really don't get the question, but when we talk about substantive validity, now there are arbitration agreements, and we can say that they are not really invalid, but they cannot be performed. So, and I have given some examples earlier. I don't know what is meant by the question substantive and formal validity. Of course, formal validity, we know that under the New York Convention, it should be in writing. We know that under the new model law, it could be oral, but we have that issue insofar as the New York Convention is concerned. Substantive validity. Well, in substance, we have already said that basically when we talk about substance, then we are talking about the contractual tax on an arbitration agreement. But it's not just the arbitration agreement or the contractual attack of the arbitration agreement. It is material because there are many arbitration agreements that are not workable, and we have mentioned some of them. I have mentioned, for example, that situation where the amount that would be in dispute would only be about 20,000 pesos, but in PDRCI, as I have said, which was the named institution, immediately PDRC will be collecting 200,000 pesos from the one who will file it. If in a situation where one party, let's say, lives in the seat of arbitration, and it's quite far from the other party, well, as we all know, one of the parties will be at an advantage. And if we are talking about a contract that is basically a contract that is a take it or leave it. So we're talking about actually the bargaining powers of each party. And so sometimes there will be a lot of unfairness, and it is up to the court of the disadvantaged party perhaps to protect its citizen or its subject. And this may also, we also are looking at the New York Convention, we are looking at the place where the assets are located. If a party has no asset elsewhere, then sometimes it's useless to initiate an arbitration if the party will be protected by, if the of the losing party would be protected by the courts of his country. We have seen a lot of cases where during the enforcement period, the country will say, well, this is against public policy, and there will be no enforcement, and it cannot be enforced anymore. So I really don't understand the question. Perhaps the one who asked it can.
Yeah, sure. So whoever sent in this question, please feel free to sort of revise the language of the question. But if I understand this correctly, so based on what you said, I think in this particular case, usually form and substance are two different things. But in this particular case, it seems form and substance are the same thing, because if it's not in the prescribed form, it doesn't have any substance. It won't be valid. So that's one way of addressing this. But perhaps, if we haven't understood the question correctly, the audience member could send it in again. If any of the other panelists would like to comment, please feel free to do so.
So we're now talking about the law governing the arbitration agreement, which again is another matter.
Right.
Because it's possible that the law governing the arbitration agreement may require a certain form for the arbitration agreement to be valid. In which case, we have to look at the law governing the arbitration agreement.
Sure. So
I think, sorry, the scope, I think he's talking about the scope and validity and the interpretation of arbitration agreements, whether it is substantively or formally. But I think the most important thing is the legal framework
Yes.
of the national law that is applicable. And also, I think what Mario has pointed out, the international conventions, particularly the New York Convention. So I think as long as that particular dispute falls within the scope of the arbitration agreement, it actually depends on the wording of the arbitration agreement. So I think that is what should be the main consideration.
Yes, of course.
Thank you, Sundra. That's very helpful. Any other panelists who would like to comment? Okay, if there are no further comments, I'll move on to the next question. So the second question is how to balance the cost and the quality of translation when it comes to international arbitration. So based on the talks given today, I think Mr. Phuntsho Wangdi would be the appropriate person to answer this question. Mr. Wangdi, did you get the question, or should I repeat it for you?
Yes, I got the question. It's regarding the translation and the cost related to the translation. Yeah, but in arbitration, what we undertake is that we must always try to keep the translation to the minimum, especially when it comes to the documents. Sometimes the documents will be in one language, two languages, three languages. Usually the corresponding documents and usually the documents are very bulky. So the arbitrators actually discourage the translation of the documents. But then if you do the translation of the documents, then it may be a waste of time because it will take a lot of time, and then may also involve a risk in that. So the documents usually which are used for arbitration should be kept as it is, and the only translation is required when they make a submission or something like that. If their things are not very clear, and then I think that whatever cost has to be borne on that has to be borne by a person to against whom interest it is paid. But as far as the main documents related to the arbitrations are concerned, we always try to discourage that there has to be very less translation issues as far as possible. So that's why then ultimately it will all depend on that. It will all depend on the translator, and then the will have to be decided with the parties. And even in that case, it's possible that the arbiters will have to make a decision on that. But to the maximum, I always say that the translation of the corresponding documents, whatever possible, should be kept to a minimum. So this is what I want to clarify on this issue.
Thank you, Mr. Wangdi. This is very helpful. If any other panelists would like to comment, please feel free to do so. If not, I'll move on to the
Yes, Sajjad. Yes, Sajjad. Excuse me. I'd actually add a little bit to what Dr. Sundra Rajoo presented in his presentation PPT. That is on the preservation of evidence. Yes, he is right. According to the arbitration law of PRCI of 1994, for the preservation of evidence, the parties had to go to the arbitration institution to ask the institution to transmit its application for the preservative measures to the court of law in China. The parties cannot go to the court of law directly. That is correct. What I want to add is that the Civil Procedural Code, which was amended later after the PRCI arbitration was promulgated, was amended, and a clause was added to the effect that the parties may go to the court of law before the arbitral proceedings has been started to request for the preservance of evidence. That means the parties may go directly to the courts of law. That's one point. The second point is that the parties may go to court of law even before the arbitral proceedings has been started. That's the point I'd like to add to the presentation that Dr. Sundra Rajoo has presented. Well, I'd like to also add one more sentence is that Dr. Sundra Rajoo sent me emails and I received it. I will answer you very soon. Okay. So that's what I'd like to say for the moment. Thank you, Sajjad. Now the floor is back to you.
Thank you, Dr. Chen. Appreciate it. So I'll move on to the next question. The question is, does BRI have any specific rules to regulate online arbitration? So I would ask Professor Sundra Rajoo to answer this question. And of course, if any other panelists would like to jump in, please.
Yeah, thank you for the question. As far as I understand, that there is actually no overall standard that has been issued. Because there is actually at the present moment we have China has together with a number of participating organizations and states have set up IPACSO. So IPACSO will be, I think, possibly the organization that would issue such kind of guidelines in the near future. But at the present moment, as far as I understand, what we see is that, for example, Hong Kong is part of China, although it's a special SAR, is still part of China, but the Hong Kong International Arbitration Center is issuing an online protocol. So other than that, I think various arbitral commissions also issue their own protocols and all these things. But there is no one standard being issued for the entire Belt and Road region, because it is actually we don't have that overall grouping, but it is being formed now. I can see that it is happening. As I mentioned, there is what is called IPACSO, the China's international organization for the Belt and Road. So it's for prevention and resolution of disputes. So it will actually, I suspect, come out with this kind of guidelines. Thank you.
Thank you, Professor Rajoo. That's very helpful. So I think because of the COVID-19, perhaps it's a reminder that ultimately we would need some type of an overarching framework that governs online arbitration proceedings. And it's very helpful to know that China is actually working on this, especially in the context of BRI. So thank you for that. Any other comments are welcome by the panelists? If not, I will move on to the next question. The next question, I think, is also relevant for Professor Rajoo. It's basically for virtual arbitration. Usually arbitration institutions use Zoom or a specific platform. I think
actually, thank you so much. Thank you so much. It's very interesting. Zoom is actually the most popular platform, but it is not very successful in certain jurisdictions. Because I think, like, for example, in China, it may actually may not be as smooth as you think. For example, we have so many platforms. We have Webex, we have Microsoft, and all these platforms. I think the most important for arbitration is the service providers. While I think we all tend to have this, like, for example, when we have virtual meetings and all these things, we have Zoom, we use Zoom because it's free, or then we pay something and the organizations use it. But in an arbitration itself, there are two issues involved. One is actually the confidentiality provisions. You need to actually make sure the arbitration is actually secure. It doesn't get listened in or whatever it is. The second thing is there is transcription going on. You have to have multi-functions going on. Many parties from different places, like what we are doing now, but they all have to be on a secure situation, and there has to be breakout rooms and other things. So normally what happens is that many of the service providers have come aboard. I think Zhejiang is one of them, in Beijing. But I also know that you can go to any great arbitral safe seat centers, and you will see that the arbitral institutions have a number of service providers you can go to in Singapore, in London, in Paris. I've been doing a number of arbitrations, and we find that you need three things from there. One, you will need a transcription service. Before that, you need the platform, somebody to actually handle the platform. And thirdly, you actually need somebody to manage it. While the platform is there, but somebody will have to say, okay, now time for this thing to happen. The arbitral tribunal will be actually quite busy trying to manage the thing. It is just like having, you going to an arbitration center. Now, what arbitration centers have become, you don't need a building anymore. What you need is to give that service, that virtual room, breakout room, other facilities, all in one online. This is actually the future of arbitration institutions. This is what arbitral institutions have to do. Zoom is only one of the preferred platforms. It depends on how stable. You see, it's very interesting. I've done, for example, where internet is not very, very strong. In some African countries, they're not very, very strong. So what you do is that you may even have a phone-in dial-in. So, somebody has to manage it. I mean, the arbitral tribunal, and I don't think so, even the parties have the technological or the, in fact, even the will, and also the time to actually manage such things. We have to leave it to professionals. So I think when I sit on a tribunal, normally we insist that we do get a professional service provider. And we organize it, and there are actually we follow protocols. I mentioned the number of protocols that were actually provided by the various institutions. They are very useful. Many arbitral tribunals will actually give directions based on such protocols. For example, you will say, okay, we will have this kind of platform. Who's your service provider? We will have a timetable. This is the way that the people will be called. The witnesses, everything will be arranged, and the the witness will be in a particular room who will have access, and we can see that, and we also can see the room is empty, there's no one else with the person. So those kind of things. So I think it's just beyond just Zoom. It's just entire whole way of doing things. Thank you, Rana.
No, thank you so much. Yeah, of course, there's many options, and of course, it depends on the parties, what they choose to have. And of course, with the growth in technology, and of course, Jian itself is taking big strides in this area. So of course, there are many more options out there. And you rightly pointed out, I think in this day and age, even arbitration centers, I think, need to learn to be more nimble and lean, be more cost efficient, because it's not just about brick and mortar presence anymore. So thank you for that. If there are any other panelists would like to comment, please feel free to do so. If not, I'll move on to the next question. Yeah, I think that is probably the last question that we received so far. It's about the enforcement of an arbitration decision or award. There's any difference between, there's a difference between decision issued by famous arbitration like Singapore Arbitration Institution and the other small ones. I think the question essentially is that, when it comes to enforcement, does it matter which institution has issued the award? I think it's a pretty straightforward one, but anybody can answer this question, please. Any panelists?
Yeah, if I may.
Yes, please.
Mario. No.
Yes.
Some institutions they have very strict scrutiny, and it's most likely the decisions issued by the institution would be enforced, because the institutions see to it that their awards or awards issued by their tribunals are enforceable. So they look at the form, and it's very, very nice when it comes out. They look at the substance, they make recommendations, and so on and so forth. Now, it's possible that some small institutions may not have scrutiny at all. And so the moment that an arbitral tribunal issues an award, they just let it go. And so quality-wise, it's those issued by institutions, by famous so-called arbitral institutions, would most likely be more enforceable than those issued by the small ones, so to speak. That's just my opinion.
Can I suggest? I think there are two types of enforcement arrangements. One is actually domestic awards. Domestic awards normally, let's say, for example, in China, it must come from a recognized arbitral commission.
Yes.
So, so I think that would be one of the requirements that you can enforce it. So it didn't really matter whether it's small or big or whatever it is. In a domestic award in China, it will be enforceable as long as the arbitral institution is actually, commission is recognized as one of these commissions. The other one is actually international. So look, if you look outside, that means you're actually using the New York Convention, which is applicable, signed by 170 countries. to enforce awards. And this enforcement of award is actually a mechanism to ensure compliance to an arbitral award. So you will have to actually meet the requirements of the New York Convention, which is ratified by the country that you're trying to enforce the award. So the institution itself doesn't really matter what it comes from, as long as it is a valid arbitral award. That's what I would like to say. So it doesn't really matter whether it comes from the most important thing is that it has to be a valid arbitral award that is enforceable. It need not come from the institution itself. It didn't matter. Many arbitrations in the world are actually done ad hoc. That means there is no arbitral institution involved. So when you look at that, it becomes quite clear then that the only thing that if you're going to a country is to look at their regime for enforcement, which is their local legislation, which would mimic the New York Convention, or they would have the New York Convention set up as a legislation as part of their local legislation. So I think that is the way I would answer the question. The award is more important than whether it comes from a well-known institution or not. Of course, I think Mario is completely right. The important part of the well-known work of the well-known institutions is that they make sure your award is enforceable, because they will actually go through a scrutiny process. It happens in many institutions, even CIICA, when I was doing an award, they actually scrutinize and they make sure the award fits the requirement where they think it's going to be actually enforced or set aside. Actually, there are three issues. One is setting aside, there is enforcement, and there is also recognition. So I think this is the way to look at it. I mean, the regime that works internationally is a bit different. But so domestic, I think, is quite straightforward. It's only setting aside an enforcement. There is no issue of recognition. So, okay, that's all, Rana. Thank you.
Thank you, Professor Rajoo. Any other comments from the other panelists?
That's the last.
Yeah, even, yeah, okay. Even I feel that as long as the parties are satisfied with the award, I think the matter of like the size of the institution will not matter much. Second is that the institution has to be legal, as long as it has license and allowed to do the job. There shouldn't be any difference. And the third is that whatever the award has been made has to be purely, first thing is based on the facts and the agreement signed between the parties. Other one is that that if that whatever the award has been passed by the arbitral tribunal, if it is based on the New York Convention, I think the size doesn't matter much. So that's why I think I don't find much difference in this, as long as the parties are happy. Sometimes there could be a case, even if the award is passed by the bigger institution, and then you know that there could be some more complications, the parties not satisfied. They can go on appealing. But even if it is small, but if that has been done, because ultimately it is not the institution. It is the arbitrators or the institution which matters. So that's why as long as the person working there is diligent enough to deliver the award, size of the institution and name will not matter much. So this is what I want to also share my comments on this.
Thank you, Mr. Wangdi. It's very helpful. Any other comments? This question seems to have evoked quite a few comments. And I think I would just add that New York Convention does not distinguish between an established institution, an old arbitral institution, and a new one, or a small one, large one. Of course, it's very straightforward. And end of the day, it depends on the quality of the award and how well it has been scrutinized. So it's a level playing field, so to speak. There's no distinction as such. There are no further questions. But if I may, because I think we have time, Bohan, is it okay if I ask? So
Yeah,
I
sure,
have a
please, sir.
sort of I have a two-pronged question for the entire panel. Anybody can answer that question. So one, when it comes to the BRI, do you see international arbitration being widely adopted, or you think in the next 10, 20 years, there'll be a combination of international mediation and arbitration, perhaps some other methods? That's the first part of the question. Second, if international arbitration you think will continue to be widely adopted for the BRI disputes, do you see certain arbitral institutions getting the bulk of the work, or do you think that it'll be sort of widely spread out and divided among different arbitral institutions? So for the entire panel, anybody can answer this question.
Yeah.
So sorry. Go ahead, Dr. Chen.
Yeah, yes, yeah, up to you.
No, Dr. Chen, please.
Go ahead, Dr. Chen, please. You can go first.
Thank you very much. So I will try to answer your two questions, and I believe the second one is more challenging. Well, as for the first one, personally, I would believe that international commercial arbitration will be adopted, will be resorted to much more in the future. I certainly run the initiative, because so far international commercial arbitration is much more favorable than the court litigation statement, at least for the Wangdi initiative countries, because so far it is very difficult for these countries to conclude some sort of multilateral conventions on the enforcement or recognition enforcement of court judgments. That's for sure. We know certainly that for these different countries, great differences between the legal cultures and the existing legal regimes. They're very, very different. It will be very difficult to coordinate these differences and reach a sort of international conventions. So I believe commercial arbitration will still be the favored means of dispute resolution. As for the second question, I think it's quite challenging. It depends on the institutions themselves, first of all. Secondly, I would think that surely the different institutions will have different promotional behaviors or measures of on one hand. On the other hand, from the arbitrator's view and the parties' view, they would have different evaluations, or will score these different institutions differently. And they would choose, I believe, to have some commercial disputes go to some institutions, where other contractual disputes go to other institutions based upon the actual transactions themselves or the special features of these transactions themselves. I think they will make different. They will for the parties and first, they would have to make decisions based upon each actual transactions to make sure which arbitration institution they would like to choose. And in some instances, which I don't think will count to much of the percentage, they will resort to ad hoc arbitration instead of institutional arbitration. Of course, overall speaking, institutional arbitration will have a better share or a bigger share of the caseload in the future. That's my understanding and observance. Thank you very much. I hope I will hear more and better ones from our colleagues this afternoon. Thank you, Sajjad.
Thank you, Dr. Chen. Professor Rajoo, please go ahead.
I think we have to look at the level of the parties. The BRI projects will work on, I think, 3 levels. First level will be country to country. That means the projects will be actually determined government to government, bilateral arrangements or multilateral arrangements as part of the overall scheme. So those projects, those kinds of projects will be insulated, because I think it will be diplomatically insulated, and most probably an SOE, a state-owned enterprise, will be asked from China to actually handle that. The second level is the SOE itself going into a subcontractors with the local, because you have to actually, let's say you're building a railway line in Malaysia, you may have to deal with the government on land and all the other things, but the SOC also has to have subcontractors because, of course, you cannot bring everything from China. It doesn't work, and then I think there will be also very strong views about technology changes and all these things. Then the third level is the subs having domestic things. Because the project is so large, the amount of money that is involved makes it, when the dispute occurs, it will be actually, the trickle-down effect will be very, very tremendous. You can actually, everybody, there will be actually almost like a feeding time, So, okay, let me put it the other way to answer your first question. I think that for the BRI initiative to succeed, the amount of disputes will have to be reduced. That's the first thing. I think the thinking process has to change. And this is where I think IPACSO is coming in again. First, we have to think about preventing disputes. That means contracts must be signed, designed clearly, signed properly. You know what I mean? People must be clear about what we are going to achieve to finish the job. Then after which, sorry, my internet is freezing all the time, so I have to do this. The next one is, I think the important thing that has happened is the Singapore Convention, which in 2019, when it was actually mooted and it became effective last year, the number of countries that have signed up, particularly in Asia, where the Belt and Road is involved, is large. So mediation settlement agreements can be actually enforced. And all the benefits of arbitration can be put back into mediation as one of the important ways of doing things. Confidential, you can actually have a win-win situation. And this is also Asian way of doing things. We normally don't quarrel. The court system is something that was actually introduced to us after the colonial times. Before that, we will have a more of a mediated, some kind of a negotiated arrangement. So I think this will become very important. Mediation will become very important, and that will be, I think, the mainstay of the Belt and Road. I think the companies, there will be actually some guidelines should come out where people will be encouraged to put in multi-tiered dispute resolution clauses that actually have a condition precedent mediation amicable settlement clause, which will be enforceable under the Singapore Conventions. And then when disputes do arise, this is where I think we are all interested to see how it's going to be arranged. I think on the large scale, government to government, it will be actually settled in a different way, most probably by negotiation and mediation. They will never go to, I will believe that China will never go to CIICA or will never go to PCA. Let's be very clear about that. So I think, there has to be another way of doing it. So this has to come out from we all agreeing with China to work out. I think what they have now done is, of course, PCA in certain bilateral agreements like the ASEAN things and all these things. But I think they will actually, where these projects are concerned, we will have to work out a system where there will be mutually agreed standards in the BRI for arbitral institutions and commissions that are recognized. There will be a list of recognized institutions. And I suppose, many of the major institutions will want to get in. ICC, SAIA, and all these things. But I think this, again, this will be actually a balancing act that has to be done. This is very political, I believe. But it is something that is necessary. It has to be thought about. I'm quite sure that people are already thinking about it, how to do this, because the amount of monies involved are very, very large. And then I think where the domestic ones, they will allow freedom. You know, in the really domestic thing, you know, how you resolve it at the bottom there, it will be actually completely free. So, I mean, this is my prognosis analyzing the overall thing, but I can never be sure because I think, you know, we have to wait until the projects move very, very quickly and as it develop, you know, which I think it is going to happen, you know, it's going to happen.
Thank you, Professor Rajoo. Any other comments? Yes, Mr.
Yes,
Wangdi, go ahead.
I also would like to support, especially on the part of the mediation, as rightly said that Asians, especially are used to doing all this mediation, and in fact, mediation and negotiation has been the practice in time immemorial, and that way, to at least to preserve the relationship, make things less complicated. And that will, I think, on the ground, I think it will solve a lot of problems, especially if the case is not of a very high magnitude issue, or if the sum is not that big. Sometimes these simple procedures, these mediations will work properly. So, other thing is that if the other option, because even the TAI in Thailand, we are also now trying to develop this mediation. Of course, like we have been mediation in the courts. But at the Thai Arbitration Institute now, we are also trying to develop this mediation, giving choice to the people, which will be much simpler. And other thing is that as Singapore also offers all this the hybrid sort of arbitration, where we initially try to do the mediation, and then later on, if it doesn't work, you go to arbitration. Sometimes just trying to solve the problem directly through the arbitration. Sometimes arbitration also becomes quite cumbersome, and then it could also take a lot of time, and the institutions might also go against the decision of the institutions. And for that, I think if you make this something very practical on the ground, and because under BRI, a lot of countries are involved in that. And like then sometimes people might choose seat of the different country, law of the different country, place of the different country. This might further complicate it. But in fact, if you do mediation, that will be better and take advantage. And only big things which are very complicated can go to the arbitration. So I think initially now, since we don't have a regulated sort of rules so far, but when we develop this sort of things, we can also have a common understanding procedure on the mediation and common understanding procedure on the arbitration. That I think we should all now come together so that everybody's interest is served. And that way, whenever there's a problem, then not everything will be on the complementary level. So that's why I just want to also just express my interest on this mediation and hybrid arbitration, where we initially start with mediation, then if not with arbitration. This is my just simple suggestion on what I feel about these procedures.
Thank you, Mr. Wangdi. Any other comments? If there are no further comments and I don't have any questions.
Something, please.
Yes, please. Sorry.
In this 1 minute, in less
No, not at all. Take your time.
Okay. I support and agree with what Mr. Rajoo said about international mediation. And I would like to say something. Actually, mediation in Middle East region is too weak and lack of international mediation. Many parties, and once any dispute is arise, everybody's said, okay, let's go to international arbitration. And I do believe that the role of Singapore mediation will play an important and efficient role with international disputes related to Belt and Roads. Maybe if Hello. Okay. Maybe if the Chinese arbitral institutions make an awareness with arbitral institutions with different areas related to international arbitration and its role of the Singapore mediation, maybe the role of the international mediation will increase in 10 years in the future. Thanks a lot.
Thank you, Mr. Sheriff. Appreciate your comments. If there are no further comments, questions, I think we can conclude this webinar. And I would like to thank Jian, Beijing Jian Technology once again for organizing this excellent webinar and bringing us all together. I think we had people from what, 6-7 countries, and it's always great to hear diverse perspectives from different jurisdictions. And I personally learned quite a bit, and hopefully all the audience members also have some useful takeaways from this webinar. You know, a lot of people say talk is cheap. I personally think that conversation happens, you know, change happens one conversation at a time. So you have to start talking about the right things, have the right conversation to bring about change. So hopefully the conversation here today will help people learn more, you know, change some of their opinions that were not correct, and of course have a better perspective and a broader perspective on the relevant issues. And on this note, I'd like to thank Beijing Jian Technology once again for inviting me to moderate and speak on this webinar. I'd like to thank all the eminent panelists for their very valuable contributions. We learned a lot from them. And so thank you once again, and I hope to see you all in person sometime soon. Thank you.
Thank you.
Thank you. Bye-bye.
Thank you,
Bye-bye.
sir.
Bye-bye.
Bye-bye. Bye-bye.
Hope to see you next time.
Thanks a lot, bye.
Yeah, we'll see you
Rajoo,
all
thanks a lot.
next webinar.
Stay safe.
That's really great. Excellent
Stay
webinar.
safe.
Nice sitting.
Bye-bye.
Nice seeing you again.
Bye-bye, everyone.
Okay.
Okay, bye-bye.
Bye, guys.
Okay, I'll get out of here.